Welcome to our second lecture relating to Chapter 14 of the textbook. As you know, this chapter has two topics, Discharge and Remedies. In our first lecture, we talked about the first topic, discharge. And we talked about the various ways that discharge can be accomplished through fulfilling your requirements under the contract, in other words, performance. The happening of some condition, this would be condition subsequent, or the failure of something to happen, this would be a condition precedent that discharges the obligation of the contract. When the other guy makes a material breach, it discharges your responsibilities under the contract. And also the parties can agree to discharge a contractual obligation. By mutual rescission, in other words, they decide to rescind the contract. By substituting a contract, the same parties will be a part of this new substituted contract, but the terms will be different. Also by accord and satisfaction, meaning a settlement agreement, and by novation, by substituting a different person in for one of the people involved in the contract. We also talked about operation of law and how that would work, and we went through some examples. This is not a complete list, but when one side intentionally and materially alters a contract, the other side's obligations are often discharged. Bankruptcy can result in a discharge. The tolling or the expiration of a statute of limitations expires or results in a discharge. Objective impossibility results in a discharge. Commercial impracticability can result in a discharge, and also frustration of purpose possibly can result in a discharge. So now we've talked about the ways discharge happens, but now we're going to flip to our second topic, to remedies. So let's get started on this second topic in our Chapter 14. When you feel that you have been wronged in a contract or really any situation, many times you confront the question, should I file a lawsuit or should I not? It's a big decision, and it's a strategic decision in many cases. There's lots of factors that go into that decision. Here are some things that you're going to want to think through. One is, how likely am I to succeed? Even if you're 100% right that you were wronged and that it was unjust what happened, it doesn't necessarily follow that the court is going to agree with you. After all, sometimes people lie. In fact, very often people lie. And some people are very good at lying. And so the fact that you're telling the truth and the other guy's lying doesn't mean that his nose is going to grow like Pinocchio and everyone will be able to see that he's lying. So you have to consider the likelihood of success. How strong are the facts for somebody who is removed from the situation? How likely are they to rule in your favor? Another factor, and this may seem kind of funny to raise this, but it can be a really important factor in some cases, is how important is that relationship you have with your contracting partner? Imagine for a second that you're Toro, the lawnmower company. And let's say you have a contract with Walmart to sell Toro lawnmowers at Walmart. Let's assume that 30% of all the lawnmowers that you sell through Walmart. So it's really important to you that you maintain a good relationship. Let's say that you conclude that Walmart has breached its contract with you. You feel like you need to explore how you can be compensated for it. But you know that the one thing you don't want to do is antagonize Walmart to such an extent that it decides to sever connections with you. It won't renew contracts. It won't negotiate additional contracts. You can't afford to let the ongoing relationship in, even if it means you have to kind of suck it up and live with the fact that the other guy is breached. Of course, there can be other situations in which it's a one-off contract and you don't ever expect to interact with this particular customer or vendor again, and then you probably don't care too much. A third issue is, how likely are you to be able to resolve this problem through some mechanism other than litigation? Tools that you might want to think about are alternative dispute resolution, which is called ADR. Here we go. Let's get a mouse here. Here we go. Alternative dispute resolution. This could be negotiation, mediation, arbitration. Those tools, how likely are they to be effective? How open do you think the other side will be to exploring those options? or just having conversations with the other side. Maybe you can point out to them that they're in breach and they'll solve the problem on their own. So exploring other possibilities, your other alternatives is an important exercise to get involved with. And then finally, you have to consider the cost of litigation or whatever other means you choose to pursue. Litigation is very, very expensive. When big corporations are sued, even in relatively silly or relatively trivial matters, they have to budget at least tens of thousands of dollars in most cases to defend those cases, even if they're persuaded that the claims are meritless. They have to invest or spend that amount of money because they have to file a response to the lawsuit, and they have to be represented by an attorney to do so. So it's an expensive undertaking to be sued, and it's also an expensive undertaking to sue. And so even if you win, sometimes you lose because in the United States, in most cases, the winner pays his legal bills and the loser pays his legal bills. There's some variation here, but that's the general rule. And so if you win the case, but you end up with a big attorney's bill, you may not feel like you really won very much at all. So there's lots of things to consider whether when you are trying to decide whether to sue or not. And it doesn't automatically follow that because you've been subject to a contract breach that the best course of action ought to be filing a lawsuit. Of course, it also doesn't mean that it's not your best option. Many times it will be the smartest path for you to pursue. There we go. Okay. So when we think about filing a lawsuit, we usually aren't filing a lawsuit because we think it'd be a fun activity to get involved with. We're curious about how the process works. No, no, and no. We are interested in getting typically money out of it. If we think that it's going to cost us more money to sue than we're going to get out of it, we're not going to sue. If we think the things that we're likely to get out of the suit are not going to justify the hassle and the expense, we're not going to move forward with that. The term that courts use for the goodies we get if we win the lawsuit is typically the term remedies. And if you think about, you've got a bad chest cold and you're coughing and you're achy and you're miserable, and your mother makes you a bowl of hot soup, maybe with noodles in it. Oh, and you still feel bad, but you feel just a little bit better. Your nose is now less clogged because you've had the steam of the soup kind of going up your nose, and the warmth has soothed your throat, and you feel a little bit more energetic because you've gotten some calories into your body. People look upon that soup as almost a remedy, almost a cure for your illness. And of course, there are actually remedies. Maybe you're on antibiotics. That could also be a remedy. So when we think about remedies in the law, we have the same idea. The remedy is what the court can offer you to solve your problem. It acts as a solution to your problem. It may not be a perfect solution. The noodle soup isn't going to make you feel better for the rest of your life. It'll probably, the effects of that hot noodle soup will wear off pretty quickly, but you will still feel a little bit better for a period of time. So it'll at least be a partial solution. There's another way of thinking about remedies, and that is to think about them as damages. It's kind of the flip side, so you could say it's the reverse of remedies, because remedies here we're thinking about how are we going to make the situation better, and damages is focusing upon how much we were injured as a result of this matter. But the two are kind of flip sides of each other, because the more your damages are, the more remedies you're going to get, right? The more you lost money because of the breach, the more money you'll be entitled to get. So you can look upon these two terms as synonyms if you want. This is talking about a solution, and this is talking about the problem, right? So whether you think about it as a remedy or damages, and both are fine ways of thinking about it, the law has broken down, or the American system, the common law system, has broken down the remedies that are available to successful plaintiffs in two categories. We have legal remedies and we have equitable remedies. We'll talk at length about both of these categories, but the important things to think about going in is that legal remedies have to do with money, with dollar bills if you're in the United States, or Canadian dollar bills if you're in Canada, or pounds, I guess, if you're in England. So it has to do with money. Equitable remedies have to do with something that isn't money, at least usually. It doesn't translate into dollars and cents. We're going to talk about legal remedies first and then talk about equitable remedies later on. We're going to cover 6 categories of legal remedies. So these are all different ways of looking at the damages that a person has experienced and translating those damages into a remedy, into a solution, into dollars and cents. And we're first of all going to talk about compensatory damages. So let's get started. Compensatory damages. These are damages that are designed to reimburse the plaintiff for his loss. The goal is to return the plaintiff to the benefit that he was supposed to receive if the terms of the contract had been correctly honored. In other words, what would the plaintiff have gotten if the defendant had done what he was supposed to do? And however far the plaintiff financially fell short of that threshold, that should be the amount that the defendant has to pay the plaintiff. The goal is to put the plaintiff in the same position he or she would have been in if the defendant had fully performed the contract. But, I mean, that's the goal of compensatory damages, but there's a couple of caveats with it. First of all, the damages must have been foreseeable by an objective person, and particularly by the defendant. We'll see how damages aren't always foreseeable. In a couple of minutes, we'll go through an example about that. So even though they're real damages, even though the plaintiff really is out money, if the defendant could not have anticipated those damages, he's not going to have to pay them. And in that circumstance, the plaintiff won't get the full benefit of the bargain. Honestly, the damages calculations are somewhat skewed in favor of the defendant. There's a concern that we don't want plaintiffs to get more than what they're entitled to. So losses that are speculative or unforeseeable, the court is usually not going to award. This category, compensatory damages, is the most important category. And when I say important, what I mean is this is where the money is. This is what the plaintiff cares about. We'll talk about several other categories, and there is money involved in those categories, but at least on a breach of contract claim, this is where the action is. If you don't have compensatory damages in your case, the attorney's likely to say to you, don't bother. This case isn't worth you going to the hassle and the expense of filing a lawsuit, except in fairly unusual circumstances. So this is where most of your recovery is going to be if you're successful in your lawsuit. Let's look at the next category. So we've talked about compensatory damages. Let's go on and talk about incidental damages. You can almost hear in the name incidental that we're talking about more trivial sums here. Damages that are related to the incident, but they're not as directly connected as we have with compensatory damages. So let me give you an example. I have a catering business, and I order, it's a new job, and the customer wants fuchsia tablecloths. I need to buy 10 fuchsia tablecloths. Well, the particular shade that the client wants is not readily available in my market, so I go to Linens R Us on the internet, and I find just the right shade, and so I order 10 tablecloths in that color. And they promise me that they will be delivered in 3 days. I give them a credit card number, they complete the transaction. I actually need the tablecloths in 10 days. So I have 7 days of play there. So if something is delayed, we're still going to be okay. So 3 days passes, they don't arrive. The 4th, the 5th, the 6th, the 7th day arrives. Even the 8th day arrives. They haven't arrived. Now I'm getting quite anxious. I've contacted Linens R Us several times, and they keep on assuring me, oh, it'll be there anytime. But this last time I've called, they seem less certain. Well, we don't know what happened. We can't track it any farther. I don't know if it's coming or not. So at this moment, I realized, wait a second, I'm going to have to cover. That's a term that we'll talk about in a little bit. I'm going to have to go out and find these fuchsia tablecloths through using some other mechanism. So I start hitting the local stores in my marketplace. There's three places I can go. One is Linens and Things, one is Bed Bath & Beyond, and there's a few others that I go to. There's a total of 4 that I go to. 3 of the 4 don't have any fuchsia tablecloths. The 4th one does, but instead of the price of $20 per tablecloth, this one is going to charge me $50 per tablecloth. The $20 per tablecloth is what Linens R Us was going to charge me on the internet. Now I'm going to pay $50. Well, that seems really outrageous. So I actually travel about 50 miles to a bigger city, and that city has 10 different stores that sell linens. After I go to the 5th store, I do find fuchsia tablecloths that are only going to be $30 per tablecloth, and so significantly less than 50. So I buy 10 of these $30 tablecloths, so I spend $300, which is I only had to, for the 10 tablecloths, I only was going to have to spend $20 per tablecloth at Linens R Us, so it's going to cost me $100 more. But that's what compensatory damages are. That's the loss of money that I have, $100, because of the failure of the plaintiff to, the failure of the defendant to fulfill his contract. My incidental damages in this case would be my travel. I have to travel 50 miles to that city, and I had to travel within my own city to these various stores. That took time. Let's say I had my assistant who I pay $15 an hour. It ended up taking, we'll say, 7 hours of her time to do all of these tasks. Well, she earns $15, 15 times 7. Here we go, 15 times 7, it looks like $105. Those would be the incidental damages. Another example would be if Al here was unfairly, illegally terminated before his employment contract was over. Well, he now needs to find another job. So the fact that he hires a search firm to help him prepare his resume, that he buys a computer program that will help put his resume together just so. He dry cleans his suit. He buys a new tie because his ties have gotten moth-bitten or something along those lines. All of those expenses are potentially incidental damages. Of course, these incidental damages have to be commercially reasonable. Going back to my example where I needed to get those tablecloths. Let's say I said to my assistant, assistant, I know you've always wanted to go to Paris, France. So what I'm going to do is I'm going to pay you to go look for a fuchsia tablecloth in Paris, France. And so your plane ticket to Paris, all of the hours you spend in transit, all of that time will be time that we will claim as incidental damages. And surely you can find 10 fuchsia tablecloths in Paris, France. Well, my assistant is delighted, and so we end up with, $5,000 in incidental damages. Well, the court would say, why did you have to go to Paris, France? Why couldn't you have found a fuchsia tablecloth in the Dallas-Fort Worth area? I don't know. Well, that's what the court will say. The court will say you don't know because that's commercially unreasonable for you to go all the way to Paris to look for something that should be more easily available close to home. If the court finds they're not commercially reasonable, the court will not allow those incidental damages to be collectible. So we've talked about compensatory damages and incidental damages. Now we're going to talk about consequential damages. These are also sometimes called special damages, and these are circumstances that arise from some special fact or circumstance in the case. The classic example of that is the Hadley v. Baxendale case. I have some information in the module about this case. You don't need to know any more about the case than what is in the textbook and that what I'm going to tell you right now, but if you are as intrigued by the case as I'm sure you will be, you're welcome to visit the material in Canvas as well. I can't remember which one of these two individuals is the miller and which one is the crankshaft repair person. I'm going to say Hadley is the miller and Baxendale is the repair guy, okay? Well, Hadley ran a mill, and in the nature of running a mill back in the 1800s, farmers would come to his mill with their wheat or whatever it was that was going to be ground. And so what he would do is he would grind the grains, and then he would return the ground grains to the farmers. But he would keep as his compensation some portion of the ground product. I don't know if it was 5, 10, 20%. I'm not sure what the percentage is, but he would keep that. I mean, obviously he could use it for his personal purposes, but he'd also likely sell it. That's how he made his money. Well, Hadley had a crankshaft in his mill, as all mills at that time had. That's how they functioned, and it broke. And so he wasn't able to use his mill at all during this period of time. So he turns in his broken crankshaft to Baxendale. Baxendale lives a piece away from Hadley's mill. He's maybe the most convenient repair person. Anyway, Hadley says, "Can you fix my crankshaft?" Baxendale looks it over and goes, "Yeah, I can fix this. Give me 3 weeks." Well, Hadley says, "Okay, that's fine," and he goes about his business. Hadley is happy with the 3-week time period because he does not expect there to be any crops that are coming in until about 5 weeks down the road. There'll be about a period of a month where it's going to be fast and furious because, obviously when one farmer's crops come in, it's about the same time that everybody else's crops come in. So there's about a month period of time where he's insanely busy, and then there's another lull. So if he can get the crankshaft back in 3 weeks, he can install it and he will be ready for the rush and everything will work out fine. Of course, he doesn't tell any of this to Baxendale. He doesn't want to, the Baxendale doesn't need to know all the details of Hadley's business. Anyway, so Hadley goes about his business. He comes back after 3 weeks and says to Baxendale, "Okay, I'm here to pick up my crankshaft." Baxendale says, "Oh, you know what? I'm not quite done. I'm going to need about another week." Well, Hadley says, "Well, okay, that's fine. I understand that." So Hadley goes back to his mill, and about a week later, he comes back and he says, "Okay, Mr. Baxendale, I'm ready to pick up my crankshaft." And Baxendale says, "Oh, I'm sorry, I've got some bad news. While I was fixing it, another part broke. And so it's actually a much more involved fix than I had initially thought. I'm not going to be able to get it back to you for at least 5 weeks. It's just impossible to fix it faster because there's various steps that you have to take, and if you rush it, the crankshaft will break and it won't be a good thing." Hadley says, "What? Well, I need it. I need it in the next week. You told me it would be 3 weeks. I was okay with that because I didn't need it until about 5 weeks. Well, now we're at the 5-week point. I need the crankshaft." And Baxendale says, "I'm sorry, there's nothing I can do. I can't get it done faster than 5 weeks. So Hadley leaves. He comes back in 5 weeks. At this point, all of the farms in the area have harvested their crops. They've come to Hadley, and Hadley's had to turn them away. So they've all gone down to another mill and gotten their grain milled. And so Hadley has missed basically the profit that he expected to make during this season because his mill was not ready to operate. So he comes back to Baxendale's workshop after the 5 weeks, and in fact, his crankshaft is ready. It's been repaired properly. Hadley installs it into his mill, and everything seems to be working fine. Hadley at this point wants to sue Baxendale for the lost money that Hadley lost because he did not have his crankshaft. Well, this would be an example of consequential damages or special damages. because these are damages that result from the special circumstances of Hadley's business. The fact that he had only one crankshaft, and that because he had no crankshaft during the time that Baxendale was repairing it, he wasn't able to run his mill, which meant he lost that business. Now, these are sometimes difficult to prove because they can't be speculative losses. They have to be foreseeable. Remember, we talked about the fact that even compensatory damages have to be foreseeable. Consequential damages also have to be foreseeable. You may recall in our story, Hadley never told Baxendale, well, I really need my crankshaft fixed, at least by 5 weeks, because I don't have a backup crankshaft, and my farmers are going to be harvesting their crops in about 4 to 5 weeks. He didn't tell Baxendale any of that information. Baxendale might have assumed that Hadley had a spare crankshaft, or Baxendale might have assumed that Hadley was from a part of the country that had already harvested its crops, or maybe wasn't going to harvest his crops for a few months. And so because Hadley didn't share with Baxendale the specifics of the circumstances, the losses that Hadley experienced because of Baxendale's delay weren't foreseeable. Now, it could be that Baxendale could have fixed Hadley's crankshaft earlier, that Baxendale kind of pushed it to the end of the queue just because maybe he had more faithful customers or more regular customers who are wanting work done. But if Baxendale had known how urgent the situation is, Baxendale might have done Hadley's crankshaft first. And so it was Hadley's error in not letting Baxendale know the urgency of the matter. Baxendale can't read Hadley's mind. And so in that case, the court said, no, the losses weren't foreseeable because Hadley didn't give the information to Baxendale that Baxendale would have needed to correctly understand the risk that Baxendale faced if he did not return the crankshaft to Hadley in the time period that Baxendale had predicted. Okay, so now we've talked about compensatory damages, incidental damages, and consequential damages. Let's go on and talk about punitive damages. This is going to be really quick because really the answer to this one on punitive damages, they're not available under contract law. You aren't entitled to get punitive damages. As you can tell from the term, punitive damages are intended to punish somebody. That's not the purpose of contract law. That's the purpose of criminal law. It's even maybe a little bit the purpose of tort law, but it's not at all the purpose of contract law. And so even though the plaintiff might want to punish the defendant, the court system isn't going to allow punitive damages. So it's very rare that they're awarded in a contract case. That will tell you that when a plaintiff is suing the defendant, he's likely to advance a variety of theories. He may have a breach of contract theory, he may have a tort theory, he may have lots of different theories. And so he might be suing for punitive damages at the same time as he's advancing a breach of contract case. But the punitive damage would stem from some other theory. So punitive damages really aren't available in a breach of contract case. Now let's talk about nominal damages. Our next two, we'll say that. So I'll get jumping ahead of myself. Nominal damages are damages in name only. You can see in the beginning of the word nominal, you have the word nom, which is the French word for name. So that might be a little bit of a mnemonic to help you remember that nominal means symbolic damages, damages in name only. Typically, damages that are nominal will be only $1, maybe $10. They're not really designed to give the plaintiff anything of value, but they're just there to show the world that the plaintiff did win, that he was the victim of a contract breach. Let me give you an example how that might play out. Let's go back to the scenario in which I'm running a catering business. I need 10 fuchsia tablecloths, and I go to Linens R Us online and I pay them $200 for 10 tablecloths, but they go missing. So now I have just a day or two to go out and find new tablecloths. I send my assistant out to find the tablecloths. She earns $15 an hour. The very first store she goes into, which is just 5 miles down the street, is having a sale on fuchsia tablecloths. They're selling them for $7 a piece. So she is able to buy 10 tablecloths for $70, which is $130 less than what we would have paid for them at Linens R Us. And the whole transaction takes her an hour. So we do have incidental damages of $15 because it took an hour of her time. But other than that, it's really a financial windfall for us. We actually made money because of the breach. But we're just so angry at Linens R Us that we still decide we're going to sue them because they did breach the contract, and it could have worked out differently. I mean, it could have been impossible for us to find any fuchsia tablecloths. Well, in that situation, we might be able to persuade a court to award us damages, but they would be nominal damages, symbolic damages. And again, this is available when the plaintiff, through no benefit of the defendant, the plaintiff just happened to luck out and did not experience any compensable harm in your particular case. In most nominal damages cases, the plaintiff goes into the lawsuit thinking that he or she has real damages, at least according to her calculation formula. If a person really thinks they just have nominal damages, they're not likely to sue, because why would you sue just to collect a very few dollars? So in most nominal damages cases, the plaintiff has a theory that they feel they can present to the jury that would present them having more than nominal damages. So people are rarely happy when they get nominal damages. And now we have our last type of legal or money damages, and these are liquidated damages. I said initially that compensatory damage is the most important of our legal remedies, and that's right, but probably our second most important, at least when we're talking about sophisticated business people who write really tight contracts. Probably the other category that's also really important are liquidated damages. Liquidated damages have nothing to do with plumbing problems or something along those lines. Liquidated damages are damages that are specified within the terms of a contract. In other words, they are negotiated when the parties are entering into the contract, obviously before any breach happened and before anyone knows for sure what the damages would have been to the breach. As we saw in the example of the fuchsia tablecloths, it can be that things are wildly more expensive and difficult to get than you expected, or it could be that they're wildly less expensive and much more attainable than you expected. You just don't know. And one way to kind of manage that risk is to establish an amount in the contract that is going to be the amount that the defendant has to pay if he breaches. And so the way this works is that instead, let's say we had a liquidated damages provision in our contract with Linens R Us. And so instead of us having to prove to Linens R Us how much we ultimately spent to acquire those 10 fuchsia tablecloths, or to also talk about how many hours it took my assistant to find the tablecloths. Instead, we would just point to the contract and say, Linens R Us, you breached. Oh, and look, let's say, oh, our contract says you need to pay us $200. Now, it might work out that our damages are more than $200. It might work out that they're less. That's not the test. The test is, what does the contract say, and that's how much is due. Now, one thing about liquidated damages provisions is they can't be punitive. So let's say in our contract we said, if Linens R Us breaches, they have to pay us $5,000. Well, that doesn't seem reasonable when the entire amount that we were going to pay Linens R Us was only going to be $200. So even a $200 liquidated damages clause actually seems rather excessive. I might say a $100 liquidated damages clause might be reasonable. But of course, you can't play, hindsight is 20/20. I mean, after the fact, you know what your damages are, and so it may well be that the provision that you have in the contract might have been wildly optimistic or wildly pessimistic. What you have to do to decide whether the the liquidated damages clause was actually punitive is to look at the situation through the lens of the eyes of the people who are negotiating the contract. Given what they knew at the time, were they making a fairly reasonable prediction about what the damages might be, or were they designing to punish a party? So why are liquidated damages provisions so preferred, so smart? Well, they remove the guesswork out of the situation. Let's say Linens R Us agrees to sell my catering business the 10 fuchsia tablecloths. But a couple minutes later, they get in another request in for 7 fuchsia tablecloths. They go into their inventory and they just have a total of 12 fuchsia tablecloths. They can't satisfy my needs and the other guy's needs. So then they might want to look at the 2 contracts. Well, if we break one, what are the damages going to be? If we break the other, what are the damages going to be? And they might decide on that basis to which one they're going to fulfill. Well, let's say one contract has a provision that says the liquidated damages will only be $15, and the other one says the liquidated damages will be $60. Well, which one are you going to fill? You're going to fulfill the one that says liquidated damages clause are $60, and then you're going to pay the $15 to the one business that had the $15 liquidated damage clause. So it allows business people to make a smart judgment about whether it makes sense for them to comply with the terms of the contract if they have that ability, or whether they ought to just go ahead and pay the liquidated damages amount. It also helps save litigation costs. Once you have a liquidated damages provision, one of the big concerns that you have going litigation, how much you're going to get out of the case, is now largely removed. Both parties know that this is the amount of money that is in jeopardy. Once the parties know that that they're both working from the same number, a lot of the reason to file a lawsuit are gone. Lawsuits are filed when there is some level of uncertainty about what's going to happen. Sometimes the level of uncertainty is about liability. I think B breached. B thinks I breached. That a liquidated damages clause doesn't solve because there's a fact issue. Who breached first or who breached it all? But if the level of uncertainty is more about how great the damages are, then a liquidated damages clause can be a really, really smart way of reducing that uncertainty and allowing the parties to resolve the dispute without getting into litigation. And again, avoiding litigation saves time, saves frustration, saves costs, and might even preserve the relationship. So we have gone through now all of our legal remedies, our money damages, and let's go to our next slide. Oops, here I went too far, sorry about that. Now we're going to talk about mitigation of damages. Mitigation of damages applies in any case. The plaintiff, no matter if it's a tort case or a contracts case or some kind of statutory claim, the plaintiff always has the duty to mitigate or to reduce his damages. This is kind of an interesting idea, and most of the time plaintiffs are kind of taken aback by this responsibility. Let me give you an example from employment law. Imagine that my boss has just fired me for a completely unlawful reason. I mean, there's just tons of documentation that indicates he fired me because of my race or my religion, whatever the thing might be. We'll say he fired me because of my gender. And there's just tons of smoking guns. I mean, there's just no way this termination is going to be upheld in a court. So let's say I was earning $100,000 in my job at the time he terminated me. So he fires me on January 1st. I go home, and you know what? I'm not even upset about it because I'm thinking to myself, I'd like to take a bit of a vacation. I'm a good saver. I've got at least enough money to live off my savings for 2 or 3 years. What I'll do is I'll file a lawsuit, and the facts are so good, I know I won't have any trouble finding an attorney, and I will eventually go to trial. I'll win the case, and the jury will award me all of the pay that I lost. And so it will be like I will get, let's say it takes 3 years for us to go through the whole trial process. Well, the jury will award me $300,000, and I will have been able to sit at home eating bonbons during those 3 years. And so that's a pretty cool deal for me. I'm mad at my employer. I'm going to get revenge, but I'm also going to be able to have an extended holiday, and it's not going to impact my financial situation at all. I might even look upon it and think, my jerk of a boss did me a favor. And so I don't look for another job. I decide I'm just going to sit at home, eating bonbons, watching TV. Maybe I'm going to take up golf or take up tennis or have some fun travel. Who knows what I'll do. But the one thing I'm not going to do is I'm not going to work. I'm not going to even look for work. So anyway, we go through the charge process, we file the lawsuit, we go through the discovery process, we go to trial, and it's just as I thought it was. The evidence is overwhelming in favor of liability. The jury doesn't need any time to deliberate. They find for certain that that my employer violated Title VII of the Civil Rights Act of 1964 and award me, and so they find in my favor. But then I have a big disappointment because they are required to calculate what my damages are. And part of the evidence that my boss showed was that if I had conscientiously looked for employment back when I was terminated on January, let's say I started on January 2nd, I probably could have found a job earning about $100,000 in 6 weeks. In my area of specialty in the community where I worked. And so really, my damages would have been, let's see, 6 50-seconds times 100. So ballpark, $3,000. Wait a second, not 3,000. Is that right? Oh no, sorry, $12,000. And that's what they award me. I'm like, but I've spent the last 3 years twiddling my thumbs. I have gone through most of my savings and all I'm going to get is $12,000. Well, they would, the court would tell me, you had a duty to mitigate your damages. You had a duty on January 2nd to go out and look for that job, to conscientiously apply for positions, to put your best foot forward in the interviews, and to accept jobs that were reasonable. You weren't required to accept a $50,000 job. You weren't required to accept a job, in Taiwan. You weren't required to accept a job outside of your field. But if it was reasonably close, at a reasonable pay rate, say within 10 or 20% of the pay that you're currently enjoying, you needed to accept that. And you did it. And so therefore, since the expert said you would have been able to find reasonable employment after 6 weeks, all you're entitled to is that first 6 weeks of pay. So you can see this is motivation for the plaintiff to go out and find that job. Similarly, when my Linens R Us didn't provide me the fuchsia tablecloths, I couldn't go out and just buy the fanciest, most expensive fuchsia tablecloths ever, when that wasn't the type of tablecloth that I had been negotiating with Linens R Us about. I needed to keep it that same quality. And I couldn't go out, to Paris and try to find the fuchsia tablecloths. I had to be reasonable and not expend too much money in terms of my damages. So I had to be kind of a good custodian of the defendant's money in these senses. And there's really 2 reasons why you want to do that. First of all, even if you win, the court is going to reduce the amount of damages you get, considering your duty to mitigate if you didn't actually mitigate. And of course, the second reason you always want to mitigate your damages is, what if you lose, right? What if you don't get any of your damages? Well, then you're going to be in a very, very difficult position, and you want to have managed that financial situation as well as you can. Okay, so now we're done with legal remedies. So now we're going to flip on over. Let me just go back here and show where we are in the course. So we've talked about legal remedies. Now we're going to flip and talk about equitable remedies. Oops, sorry about that. Okay, so what is an equitable remedy? Well, first of all, it's a non-monetary remedy. It's also a court-ordered action. The truth is that courts like to award legal remedies a lot more than equitable remedies. It's a lot easier to give money than to draft a court order. If you give money, you're not going to have people back in your court complaining, well, he didn't do what your court order said, that kind of thing. So money doesn't always solve a problem, but certainly court's first inclination is, let's go with money. And usually, especially in business situations, that's what the parties care about. I mean, there isn't a lot of sentimentality in business. Usually the solution to a business person's problems is money. But even in business, there are times where something other than money is what the person actually needs. So, what types of evidence does a plaintiff need to present to the court in order for the court to seriously consider awarding equitable remedies, either in addition to or instead of legal remedies? Well, here are 5 factors that the court is likely to want to have information about. First of all, the court is going to want to be persuaded that there is no adequate legal remedy available under these circumstances. There's just nothing in terms of dollars and cents that's going to solve the plaintiff's problems. Let's imagine that this case has to do with a trade secret. I had an employee and he got access to my trade secret, and then he has been threatening he's quit my company, he's been threatening to sell it to my competitor. I want an injunction to shut him up, because once this trade secret is public knowledge, all of my competitors are going to be able to produce the same quality items that I've been producing. My business model is shot. So what I probably want money from this situation, but I also want an equitable remedy. I want the court to order this former employee to keep his mouth shut. That is really what I need. A legal remedy, money, isn't really going to solve my problem, because every year from this point forward, I'm going to lose income because of this lost secret. Another thing the courts are going to be looking for is that irreparable harm to the plaintiff may result if the equitable remedy is not granted. So this is something that if the equitable remedy is not granted, there's no going back. There's no fix after the fact that is going to make everybody happy, that's going to make the plaintiff okay. Again, the example of loss of the trade secret. You can't unring the bell. If you are a KFC and you've got 11 secret herbs and spices, and one of your employees sells that secret to, Bob's Chicken, and now Bob's Chicken is as popular as KFC, there's no way you can, call up your customers and say, hey, customers, you shouldn't shop at Bob's because the trade secret was stolen. Customers are like, well, we don't care how Bob's got the 11 herbs and spices. We just like his chicken. And so we're going to eat his chicken and not yours. So there's no way you can talk your customers back into wanting to eat your chicken under those circumstances. That would be an example of irreparable harm. Number 3, the other thing the third thing that the plaintiff is going to have to prove is that, this is not always, usually this is a requirement, that the contract is legally valid. This flows with the idea that the plaintiff has clean hands. So let me talk a little bit about clean hands first. I have a picture of someone washing their hands. The term clean hands in the law, though, doesn't refer to good personal hygiene. There is a story in the New Testament of the Christian Bible. It's in the Gospels, in the first 4 books of the Christian Bible, that it's at the time that Jesus is being tried for crimes that the Roman official Pilate thought that he had committed. And after Pilate condemns Jesus to death, he asks for a bottle, not a bottle, but a bowl of water to wash his hands. And this was a custom apparently in Rome at this time, that you would metaphorically wash your hands to remove any guilt, any soiledness from your hands. And that was a way of kind of purifying yourself from this action of rendering this death sentence. And so as a result of the story, that became a very important part of Christian culture and the Christian faith, this obviously most people in England at the time the common law was being developed were of the Christian faith, and so they were very familiar with this story. And so when they were developing their equitable system, they said, well, we want to make sure that if the plaintiff is going to collect money under an equitable theory, that he's behaved himself. He's done the things that he ought to do. He's a pretty darn good guy, at least with respect to this particular case and how he's treated the defendant. Now, at law, we don't really care so much about whether the plaintiff is a stand-up guy or stand-up woman. We're more focused upon what the defendant did. But in the equity, we care. If the plaintiff did some bad things and the defendant did some bad things, under a legal system, under a legal remedy, the court may be willing to offer some remedies. But under equity, if the plaintiff doesn't have clean hands, if he has misbehaved, the court will say, we're not even going down the equitable road. You know what? You can get legal remedies all day long, but we are not doing the equitable remedies because your hands are dirty, metaphorically speaking. So that fits along with the idea that the contract itself has to be legally valid. If there's some kind of irregularities with the contract, something about the contract perhaps was illegal, or there was some duress, or the defendant maybe lacked competency to enter into the contract, the court would be basically saying, the plaintiff doesn't really have clean hands in this transaction, so we don't want to award an equitable remedy, even if we think we can award a legal remedy. Now we're going to see one exception to this, and that is in the quasi-contract theory that we'll talk about in a few minutes. So it isn't applying 100% of the times. And finally, the contract terms have to be clear and unambiguous. Courts are only going to be willing to award equitable remedies when it's quite obvious that they are appropriate. If it's maybe it's appropriate, maybe it's not, the court is going to side with the defendant in those cases. Award legal remedies, but not award equitable remedies unless it's a clear-cut case. The nature of equitable remedies, unlike legal remedies, is that it requires a court order. The court has to fashion a remedy that is going to solve the problem. So it's involving a fair amount of heavy lifting on the part of the court, of fashioning the language, of tweaking the language maybe that the plaintiff's counsel has given to it, to anticipate all the different crises that can come up over the long haul in the situation. So it's a more involved process than would be if we were awarding legal remedies. So we're going to consider several common equitable remedies. I mean, there's dozens of them, so this is by no means an exhaustive list. We're going to look at rescission and restitution, specific performance and injunctions. We're going to look at reformation. We're going to talk about that quasi-contract possibility, and then we're done. So let's go through these. So first of all, our textbook lumps rescission and restitution together. Rescission is, of course, the noun version of the word to rescind. And we actually talked about this in an earlier section, I think maybe even of this chapter, where we said that a contractual obligation can be discharged by mutual rescission. When both people want out of the contract, then actually there's no even need to go to the court. Both parties say, okay, we don't want to do this contract, so we're not going to. Rescission that is an equitable remedy would involve the court saying, okay, I'm terminating the contract. Now, of course, in this situation, one party, usually the defendant, still wants the contract to continue. But the court is saying, we're not going to do this. So the court would draft an order that would say this contract, which ordinarily would be a perfectly lawful and enforceable contract, we are rescinding it or terminating it. So that's one remedy that can happen in an equitable remedy situation. Another is the situation of restitution. In this situation, we are restoring the person to the situation that he was in prior to that contract. So this would be items that might be returned to the plaintiff. Let's say that the plaintiff paid $10,000 for the widgets. Well, the widgets never came. Or let's not say it was $10,000. Let's say this was a barter situation. So the plaintiff agreed to paint a portrait of the owner of the widget factory, and the widget factory owner would send 200 widgets to the painter's house. The painter awarded the or sent the painting over to the widget factory owner, and then he, excuse me just a second, please. Okay, so he send it over to the painting over to the widget factory owner, but the widget factory owner never sends over the widgets. Now, you, the plaintiff, you're suing over this, you want that portrait back. Well, that would be an example of restitution. So in that situation, the court would fashion an order that would require that factory owner to return that portrait back to you. So those are two examples of equitable remedies. Now we're going to talk about specific performance. We talked about the idea of performance in the first half of this chapter, and we talked about how it doesn't mean, you know, a play performance or a singing performance or anything like that. When we talk about performance under contract law, we're talking about doing whatever it is you have agreed to do in the contract. So specific performance is when the court tells somebody, okay, in this contract you promised to do X, Y, and Z. So guess what? You need to do X, Y, and Z. You still have to fulfill your obligations under the contract. Now, many times plaintiffs don't even want defendants to fulfill their contractual obligations. It could be that the plaintiff has already sought cover, and so he or she doesn't even need whatever it was the defendant was supposed to do. So it's not inevitable that the plaintiff wants to have specific performance, but in some cases, especially let's say I'd entered into a contract with Claude Monet for a painting, I might still really want a painting by Claude Monet, assuming he were still alive, right? So that could be an example of specific performance. Courts are fairly reluctant to order specific performance if it's not as simple as just return this stuff. If it actually involves a fairly significant amount of effort, it can get to be pretty difficult situation pretty quickly. Imagine that the court requires that Claude Monet paint the Monet painting. Well, he might do, let's say his average painting takes him 50 hours to paint, but he might dash off a painting to me in 30 minutes. It's not going to look like one of his famous impressionistic paintings. It's probably going to look pretty bad. Probably even Claude Monet can turn out a bad painting. And this would be especially true if he's pretty ticked at having to do this to begin with. So he might intentionally produce a bad painting. So you can see how requiring specific performance does make a situation a little bit more complicated, hard to draft the order, hard to make sure that the defendant who's being forced to specifically perform is really going to do a reasonable job. So it does open up a lot of can of worms, so to speak. And in fact, there's another problem with specific performance that I don't have listed here, but I think it's helpful to consider, and that is the fact that because of the 13th Amendment to our Constitution, 13th Amendment, as you know, is one of the Reconstruction era amendments that prohibits involuntary servitude in the United States. Courts have a limited ability to force individual defendants to perform acts such as paint this painting or build this bridge or something along those lines, because basically what you would do in that situation is it would be the court system forcing somebody to perform certain types of labor for no compensation no additional compensation. And so it would be similar to involuntary servitude. And so you really, it's pretty difficult to order an individual person to do that. Now, of course, a court can force a corporation to hire somebody to do a particular task. That would be fine. That wouldn't involve 13th Amendment issues. So specific performance is a fairly common remedy, but you can see there's lots of things to think through before you request it, and if you're the court, before you grant that type of a remedy. Really, all of the, actually not so much rescission, but the first two that we're talking about are really special cases of injunctions. Injunction is a large term that has to do with a court order. Really, all an injunction is a particular type of court order where the court tells a party, in this case the defendant, to either start doing X or stop doing X. It can be either way. And it can be very detailed, very involved. It might be, an injunction might be telling a particular company that it cannot put certain chemicals out of its smokestacks, or it can only have this percentage of its smokestack emissions being of this particular chemical. So it can be something along those lines, but it could also be an injunction that tells the defendant to restore property to the plaintiff, or it could be an injunction that requires specific performance by the defendant. So these are special categories of this larger term of injunction. In the case of injunctions, many people think about an injunction being a kind of a timeline issue. Courts can award injunctions at the end of a trial, after the evidence is heard, and then the court can consider, so here's trial, and now this is at the end of trial. The court might say, well, I have concluded that at the equitable remedy that the plaintiff has requested is appropriate, and I'm going to order an injunction. That type of injunction after trial is called a permanent injunction. It's called a permanent injunction, but it doesn't mean that a defendant can't appeal the injunction. It just means that, assuming that if it is appealed, that the decision is upheld at the appellate court, that this is a final deal, that this injunction will remain in force essentially forever. But from the time that the lawsuit is filed until you get to the end of trial can be a very long time. It can literally be years. It can definitely, almost certainly, be many, many months. And you can see how circumstances can arise that really you need to maintain the status quo right now. Going back to the example of my business, I'm KFC. I have this former employee who knows these secret 11 herbs and spices. He can sell that in a heartbeat to a competitor. And so I can't wait months to get to trial to then have the court order him to keep the secret. I need to get the court to immediately order him to keep the secret, and then we'll go to trial, and then we'll see what the court says at the end. Well, can be a three-step process. We've talked about a permanent injunction at the end of the process, but there can be two steps that happen before the permanent injunction. The first is a TRO, temporary restraining order. This is sometimes the first step in the process. This is probably what I would do in the case of the stolen trade secret. I need to, as quickly as humanly possible, get into that hand of the ex-employee this injunction. So if he breaches it, if he goes ahead and blabs to Bob's Chicken about the secret 11 herbs and spices, he is now in contempt of court. And so I don't even have necessarily hours to develop this case. I am immediately contacting my attorneys, and they are rushing down to the courthouse to have this temporary restraining order hearing. But one of the issues about temporary restraining order hearing is that they're usually ex parte, meaning only one side, only the plaintiff side is going to be present. I mean, the ex-employee doesn't even know about the hearing when it's initially taking place. So his evidence, his testimony, the arguments that his attorney might advance aren't going to be heard by the judge. So if the judge grants the TRO, he's not going to grant it for a very long period of time. He's going to say, look, I recognize this is a super urgent matter, and we need to maintain the status quo for a period of time to make sure that these secrets don't get out, because once they're released, you can't ever corral them back. So I get why we need the TRO, but as soon as possible, typically just a few days, we're going to need to have a hearing on a preliminary injunction. That will replace the TRO, and this preliminary injunction, if I grant it, will remain in force until we get to the end of trial. And then, if I deem it appropriate, we'll replace it with a permanent injunction. Of course, when we have the preliminary injunction hearing, I might, when I hear the evidence from the other side, conclude, oh no, an injunction isn't necessary or appropriate. Or even if I find that the preliminary injunction is necessary and appropriate, after we hear the whole trial on the merits, I may conclude that a permanent injunction is not necessary or appropriate. So I wanted to make sure that you're familiar with kind of this timeline. I don't think we're specifically addressing the issue of the temporary restraining order or TRO, but it is useful for you to know the distinction between a preliminary injunction and a permanent injunction, which is probably just be a regular injunction. Let's talk about Reformation. I have a picture here for those of you out there, history buffs of Martin Luther. He is putting up his 95 theses on the Wittenberg door. That he, of course, is an important character or figure in the Protestant Reformation that was important in England England and Europe during the Renaissance. But that, of course, is not the Reformation that we're talking about here. Instead, we're talking about Reformation to mean the reforming of something. We are reforming a contract. Many times this arises when there is a typo or something in a contract. For example, let's say a contract says $200, comma 000, and then parentheses would say $20,000. Well, which one is correct? This actually says 200,000. This says 20,000. It seems like an extra zero got added here. Usually the written in words number controls over digits because it's a lot more unlikely that you would type 20 when you meant 200, right? But adding an extra zero, the key sticks or something like that, you can imagine that happening. But let's say that in this particular contract, they hadn't written out the sum. All we had was this $200, comma 000, but it ends up that really the whole history of the contract was they'd always been talking about $20,000. This was just a case of a typo. Well, the court might order equitable relief of altering the contract, the court order altering the contract by removing one of these zeros. That would be to reform or rewrite the contract. Okay, let's talk about recovery based upon quasi-contract. We touched just briefly on this topic when we were here because we talked about one of the things that the court, one of the 5 things that the court is interested in, and this actually isn't an exhaustive list of the things that the court would be interested in, but 5 of the things the court is interested in is that the contract itself be legally valid. But then again, we had this one exception, unless we're looking at a quasi-contract theory. Well, let's look at that quasi-contract theory then. Let's go to that particular slide. Oops, sorry about this. Okay, so what is a quasi-contract? We've talked about this before, so the term might ring a bell. Whenever you see the term quasi in the law, the way I like to think of it is kind of, sort of, but not quite. It kind of quacks like a duck, it kind of waddles like a duck, it kind of has feathers like a duck, but it's not quite a duck. So it's close, but no cigar. That's the idea behind a quasi-contract. There's some fatal flaw. Let's go ahead and pull up for a second our elements of contract law. Here we go. We have our elements. So a quasi-contract has something wrong with it. I mean, it has a lot of the stuff you expect to see in a contract. It just doesn't have everything we expect to see. Maybe it has an agreement with an offer and acceptance. And maybe the offer has all 3 of the requirements of an offer. And maybe the acceptance has all 3 requirements of an acceptance. Maybe there really is reality of assent to what we talked about in Chapter 12. Also, in addition to having an agreement, perhaps the contract has consideration. And all 9 rules of consideration are satisfied. In addition, perhaps both parties have contractual capacity in that they aren't minors, they aren't intoxicated, and they aren't insane or having another intellectual limitation. Maybe all of the aspects of the contract have a legal object, both in terms of a legal subject matter and also it can be performed legally. But if even one of these items is missing, or even a subcategory of one of these items is missing, then we have kind of a fatal flaw with the contract. We can't call it a contract. It may be very, very similar to a contract, but we can't call it a contract. The court isn't going to treat it as a contract. The court's going to say, this isn't a contract. So what the court might do, and the key word here is might, because the court isn't required to do this, but the court might say, it's not a contract, so I can't treat it like a contract, but it doesn't seem just to not do anything to help out the plaintiff in this case. Typically, a court will enforce something that isn't a contract when these facts are in evidence. The plaintiff conferred some benefit to the defendant. The plaintiff had reasonably expected to be compensated for the benefit conferred to the defendant, and the defendant would be unjustly enriched if he received the benefit without compensating the plaintiff for it. Let me give you an example. Imagine that Bob is driving around town and he's in a bad car accident. I mean, we'll say it wasn't his fault, but it doesn't really matter. It could be his fault, could not be. The ambulances arrive, they transport him to the hospital. I mean, it's bad. He's unconscious. When they wheel him in, the emergency room physician looks at him. He has very, very low blood pressure. He's bleeding all over the place, massive internal injuries. The physician immediately determines that Bob needs immediate surgery if he's going to pull through. Bob is unconscious. He can't consent to anything. Bob was traveling alone at this time, so there's no one in the car that would be able to provide consent. They're trying to contact Bob's wife, but they can't reach her. They can't wait any longer. If they wait even 10 more minutes, Bob will probably be dead. It will be too late to save his life. So the emergency room physician says, we got to go. They roll Bob into the emergency room. The physician immediately starts the surgical procedure. Even though there was very, very dramatic injuries that Bob experienced, the emergency room physician is able to save Bob's life. He is going to live. He's going to fully recover. It's just tremendous. He's tremendously lucky that he survived this particular event. Anyway, so Bob is waking up. He's in recovery. He's groggy. He's in a lot of pain. He's confused. He looks up and he sees the physician there. And the physician says, Bob, can you hear me? And Bob says, yeah. Where am I? What happened? And the physician says, don't worry, you're fine. You're in the hospital, but you're going to be just fine. We've done all the steps that we need to get you back on track. The prognosis is very good. Your wife and your children want to see you soon, but before we had them come in here, we wanted to make sure that you were situated, you kind of knew what was going on. Okay. So a few days later, the physician comes back and says, listen, Bob, you're doing great. So pleased to see the progress that you've made. I wanted to go over the procedures that we performed while you were unconscious. We needed to, your spleen had ruptured. We needed to repair that damage. One of your lungs had collapsed. We needed to repair that damage. You had 4 broken ribs that we needed to confront. There was some bruising of one of your kidneys. We needed to perform some procedures with respect to that. There were several other injuries that had resulted in a significant loss of blood. We had to suture up some blood vessels, but we caught everything. Your blood pressure is great now. There's no signs of infection. It looks like you are going to recover fully very, very soon. Bob says, well, gee, this is great news. Thank you. Thank you, doctor, for all that good work that you did. And the doctor says, well, thank you for saying that, Bob. It's my job to do that, but you should know that if we hadn't been able to perform the surgery when we did, if you, for example, hadn't come into the emergency room, even if you had been 10 or 15 minutes later, we probably wouldn't have been able to save you. It was that close. You almost died. And so you're right to recognize that this was a very, very big event. And so Bob says, well, again, thank you for all of your effort. And the doctor says, yeah, of course, as you know, my services don't come free. The hospital isn't a free institution. So when you check out, you'll be given a bill that will itemize all these various expenses related to the surgery. And Bob suddenly says, what do you mean? Well, you know, there was my services, there were nurses that were performing parts of the procedure, there was an anesthesiologist that was there, I had an assistant surgeon assisting me, we had to use equipment that the hospital provided, the use of the use of the surgical theater we had to have, and then there were the recovery room nurses who've taken such good care of you. All of the medication that you've taken while you've been recovering, all of those things obviously aren't free. And we have, you know, been incurring these expenses, and so that'll be part of the bill that you'll need to pay at the end. Your insurance may help. I hope it does, but somebody, either you or your insurance, will need to pay these bills. Bob goes, but we didn't have a contract. Doctor's a little taken aback. Well, you know, of course we didn't have a contract. You were unconscious when you came in here. We couldn't enter into a contract. You weren't, you didn't even know your own name at that point. And Bob's goes, well, you know, I'm very appreciative of the fact that you performed this surgery on me, but you performed the surgery without me ever saying that I agreed to any of this. And so we don't have a contract because we didn't have an agreement. I never accepted your offer to perform this surgery. I never manifested an intent to be bound by the acceptance. I never agreed to this definite and certain terms of your offer to perform this surgery, and I never communicated my acceptance to you. Because I never accepted your offer, we never had an agreement. And because we never had an agreement is an element of contract law, we never had a contract. So you can't sue me to collect money because there is no contract. Well, of course, the doctor's a little taken aback. Bob, I thought you were grateful for me. Where is this coming from? Bob says, well, I am grateful. You were kind to me. You did perform this service out of the goodness of your heart, and I am genuinely appreciative, but I don't intend to pay anything for it. Well, this is when the doctor kind of gets up, probably in a huff, and goes about his business. But if Bob sticks to his guns and doesn't compensate the hospital or the doctor or the doctor would sue under a quasi-contract theory. They would say, look, the hospital and the doctor did confer a benefit to Bob. If they hadn't performed the surgery as well as they did and as quickly as they did, Bob would have died. Being alive is a benefit to Bob, right? And then the next statement is also true. Doctors and hospitals have a reasonable expectation that they'll be compensated when they benefit a defendant, or when they benefit a patient. Emergency rooms wouldn't be able to exist and make money if anybody who was brought into the hospital unconscious would be exempted from having to pay for the services. That wouldn't be a socially useful situation. So it's reasonable that hospitals and doctors can expect to be compensated under those circumstances. And finally, Bob is being unjustly enriched if he doesn't pay for the services he received. After all, he is alive today because of these services. So it's not fair that he gets to continue being alive and gain the benefit of those services without paying for those services. And so the court is going to award recovery under this quasi-contract theory to avoid an injustice, to avoid Bob getting free medical services, even though Bob may well be a multimillionaire who could easily afford to pay for these. And this would be detrimental reliance. In this case, the doctor detrimentally relied. The doctor probably had a better way to spend his day than to be performing surgery on Bob, but he relied upon the fact that Bob would want his own life to be saved, and that he would be willing to compensate the doctor reasonably for that. So The doctor gave up his time to perform the surgery, relying upon that fact. So under those circumstances, the court could order recovery based upon a quasi-contract theory. Now, this is the one category of our equitable remedies that seems most like a legal remedy, because probably recovery in this situation is going to be dollars and cents. I mean, after all, the doctor doesn't want anything from Bob other than money, right? He doesn't want, Bob's baseball card collection or anything along those lines. He wants cold hard cash. And so sometimes equitable remedies can actually look just like legal remedies. I mean, it's just a certain number of dollars and a certain number of cents. But it's the logic behind how you reach that calculation that is where equity is involved. Because, of course, you couldn't award a legal remedy when we don't have a contract. The whole idea of this quasi-contract theory is an equitable concept. Under the law, our legal system that we have, we think about how you advance a claim. We think about looking at all of the elements. Do we have all of the boxes checked? And if we can't check all the boxes, the law says, oh, you're out of luck, plaintiff. Sorry, but you can't win. And sometimes that seems like a pretty harsh result. The plaintiff might have a case that you hear that you think, oh gosh, plaintiff really ought to win under these facts. It doesn't feel right that the plaintiff isn't going to win. But the law says, we don't really care what feels right. We care about getting our boxes checked off. We care about this process. And we recognize sometimes really nice people are going to not get the money they feel they should get, and really awful people might get money that maybe other people don't feel they should get. But we care about following the letter of the law. But equitable remedies are a little different. The court has more freedom to innovate, to be creative. It's also what I like to call, a highly technical term here, loosey-goosey justice. The court has more of ability to look at the big picture, to say, what feels fair to me? What seems reasonable under these circumstances? You might think to yourself, well, why don't courts always do that? Well, courts don't always do that because what one judge feels is fair and reasonable may be very different than the way another judge thinks about a situation or about how other people think about it. As soon as you get into an equitable evaluation system, it becomes pretty darn subjective pretty quick. And so one person's values might kind of overwhelm another person's values. We like to have that fairly rigid system because it allows there to be a lot of consistency. So most of our system is this legal system. Probably 90% of it or more is the legal system. But we do have this kind of backup system in reserve that kind of fills in the gaps where we really feel like the legal system, as cool as it is, kind of messed up in this case. And so we allow it to fill in the gaps. And so this is one example where we have an equitable remedy that really does gets reduced to dollars and cents, but it's the logic behind it, how it's being awarded, not so much the fact that it's actual dollars and cents that what makes it an equitable remedy. So now we have completed both of the topics in our chapter. We've talked about contractual discharge, which again is a good thing, and we've talked about remedies, the solutions to the problems. We've talked about legal remedies and equitable remedies. If you have any questions about either discharge or remedies, please feel free to come by my office, send me an email, or raise those issues in class. I thank you for your attention, and I look forward to seeing you soon. Have a wonderful day.